We have read your very rich CV and all the material that you have presented before us. So what I want you to do is to tell us, to begin with, who is Professor Akech. Not what you do, because we know what you do. It's all in the documents you have given us. So for me, you will answer 4 questions. Who is Professor Migai Akech? And what special skills, knowledge, and value that you're going to bring to the Judicial Service Commission?
So if I may start by who I am.
Yes.
I like to think of myself as being an activist citizen and a Pan-Africanist. I care deeply about this country, and I've tried to make it a better country. I care deeply about my continent as well, and I've tried to make it a better continent. I am a sports person. I play football. I still play football to date. In the game, I play as a defensive midfielder and the combative one. So I like to tackle in the game of football. I believe in justice, and that is why I have studied law and spent my career in the legal profession.
That is who you are. So what special knowledge and skill are you going to bring to the Court of Appeal?
When I reflected on that question, I thought that given the nature of courts of appeal, because they're courts of record, they're courts that deal with documents, that my background as an academic qualifies me, especially to be able to be an effective Court of Appeal judge. I am an excellent researcher, I would say. I've done that for 27 years. I'm an effective communicator, having been a teacher for 27 years, both orally and in written form. I believe I write very, very well. I write in a very balanced way as well. So I think words like hot air will not find their way in my judgment. And I also bring my willingness and ability to learn. So you'd know, for example, that I thought that it would be useful to learn as much as possible the work of the court. So I've done quite a bit. I have read, I believe, some 60 or so judgments of the courts in the last 6 months that I've been preparing for the opportunity. I have interviewed the personnel of the court, so a very good sense of the work of the court, the challenges that it faces. And I did that because I want to be ready on day one.
Mm-hmm. Very well. I think your last sentence will be leading us to the technical area when you say you have read the judgments of the court and you are ready to go. So I will ask Justice Ishare to take us to the next set of questions.
Thank you, Honorable Chief Justice. Professor, 1 or 2 questions from me. And indeed, you're right in saying that we are looking for persons who are judge-ready for the job. But let's begin with the jurisdiction of this court. Article 164(1) of the Constitution provides that the jurisdiction of this court is to hear appeals from the High Court, from other courts, as well as from the tribunals. So you have the mandate of the court being hearing or dealing with appeals, and then you have the provisions of Section 5(2)(b) that provide for applications for stay, which in this case is not an appeal when you're dealing with an application. So is one right in saying that it is unconstitutional for the court to hear 5.2b applications because the setup of the court is to hear and determine appeals?
The short answer is no, it is not correct. And it is not correct because every court, whether it is a high court, a magistrate's court, a Supreme Court, a court of appeal, must have what are called inherent powers. The court, for example, must be able to have the power to preserve the substratum of an appeal, for example, or a case before it. So if you were to say that a court of appeal, or that the court of appeal only has jurisdiction over appeals and not what do you call it? The interlocutory matters that parties may bring before it, then you're disabling that court. You're undermining the power of the court to be able to do its work. And in that sense, I think that is not unique to courts, if I may just look at it as in a broader framework. I think the same question arises, for example, in the context of the executive, where presidential powers, for example, are not always specifically designed, but a president, for example, must be able to do certain things that are inherent to the executive power. So I would look at it, I think different descriptions of this power in the cases would talk of the discretionary powers of the court, but I think the correct term for me would be a court must have certain inherent powers. I hope that answers the question.
It does, but is there any way that an application under 5.2b is linked to an appeal?
Yes, it is. I think if you look at the definition of in section in the rules of the court, the Court of Appeal rules, if you look at Rule 2, I believe, it defines an appeal as including a notice of appeal. And that is for a very good reason, because a person that intends to appeal, for example, wants to be able to, even before they file the notice of appeal, they want to be able to preserve the subject matter of the appeal. So, for example, in a case where you want to stay the execution of the judgment that is from the High Court, then it is important that the court that is being appealed to is able to freeze matters, and it cannot do that unless it has the power to be able to make interlocutory decisions over the intended appeal.
Thank you. I think I'm hearing you saying that an application under 5.2b is intrinsically linked to an appeal?
Yes.
Because you have to file a notice of appeal.
Correct.
That's correct. Now, still on the 5.2b applications, there is a litigant who has appeared before the Employment and Labor Relations Court seeking several remedies, including a remedy of reinstatement because he has been fired or she has been fired by her employer. The Employment and Labor Relations Court deals with the matter, and at the end of it all, it dismisses that suit. This applicant, now an applicant, comes to the Court of Appeal seeking an order of stay. Please tell us how you think you would determine such an application.
Can you just repeat the question again?
Okay. A litigant has gone to the Employment and Labor Relations Court seeking several remedies because he has been fired by his or her employer. the court, the Employment and Labor Relations Court does not determine that suit in his favor. In other words, his suit is dismissed by the Employment and Labor Relations Court. He is dissatisfied with that outcome, and he comes to the Court of Appeal under 52B, seeking to stay the orders of the Employment and Labor Relations Court. And because you're telling us you're judge ready, how do you think you would handle such an application?
I think that there are two things that in Rule 52B the court will look at. First of all, the court will say, is the appeal arguable? Is there any issue that the intended appellant would be raising that is arguable, number one. But number two, would the failure to grant those orders render the appeal nugatory? So I think I would apply that two-part test in determining whether or not this individual would be entitled to those interlocutory orders.
So I would like you to apply those two principles to the scenario that I've given you.
First of all, I don't think there's any right to stop someone from being dismissed as such. I think it would depend on the contract. But if, for example, the contract says that you're entitled to notice, let's say it says a 30-day notice, then I would ask, was that notice granted? But I don't think somebody would be, so it would be, on that basis, I think there would be an arguable appeal. But on the second issue, on the second question of whether it would be rendered nugatory, that may not necessarily be the case, because this is somebody that can be compensated, for example, in damages. So I would not then grant the order on those facts.
Is there any significance to the fact that the order that was made at the Employment and Labor Relations Court was a negative order?
Negative in terms of?
It was dismissed.
Would it be?
Is there any significance to the fact that this suit was actually dismissed, the suit that he seeks an order for stay, the order of the Employment and Labor Relations Court was a negative order?
Is
Yes.
Is there any significance to the?
Is there any significance? Remember, you're handling a 52B application.
Yes.